I am the director of the Fair Housing Project of Legal Aid of North Carolina. We do three things. We do educational trainings like this. We do fair housing enforcement work. We will actually, if it gets to a point where something can't be resolved informally, we will actually file fair housing administrative complaints, whether in administrative agencies like the North Carolina Human Relations Commission or Charlotte or some of the other substantially equivalent agencies, or we will file complaints in state or federal court. The third thing that we do is that we have fair housing testers. We will send out testers to housing, multi-family housing or even public housing to determine whether individuals are being treated fairly and equally, or whether they are being treated in a discriminatorily different way, whether that's as a result of an individual request for us to come out, or sometimes we just do kind of spot checks, just sending folks out. We are based in Durham, but we cover the entire state in terms of the work that we do. So if you give me about an hour and a half of your time, I'm gonna give you a basic overview of the Fair Housing Act and what it requires, the rights and responsibilities that are related. I'm gonna focus on, in addition to just general aspects of the Fair Housing Act, I'm gonna focus on the rights of tenants with disabilities and what the housing provider responsibilities are there. I'm going to talk about renting with a criminal history and what that entails. And I'm going to focus on the fair housing requirements for recipients of HUD monies, whether it's CDBG or home monies or any HUD monies that a recipient or subrecipient has, and with that receipt of the monies come certain fair housing requirements. And so I'm going to go over that as well. I love questions, and so if individuals have any questions, there's no need to wait till the end. Please just put your question in the chat box, and if I don't see it, Erica has told me that she's going to monitor the chat box, and she'll just let me know about the question, and I will try and address that as I'm going forward. There's no need to wait. And so please certainly ask questions if there's anything that I say that is unclear or confusing, or you just have a question about anything that I said. Certainly, please just put it in the chat. Okay, so without further ado, I'm just going to go forward. Right. So there are various different anti-discrimination laws that cover both what local governments do in their zoning and planning, as well as what housing providers do in the provision of housing. And there's obviously the Federal Fair Housing Act. That's what I'm going to focus on. There is a State Fair Housing Act that we have here in North Carolina. And then in addition, there are local ordinances that various counties and municipalities may have. Specifically, HUD has recognized Charlotte, Meck, Greensboro, Winston-Salem, Orange County, and Durham as having what are called substantially equivalent fair housing ordinances. They have been approved by HUD to have their own fair housing enforcement procedures. And so individuals can file fair housing complaints either with our state agency, with HUD, or with any of those individual entities that I just mentioned. So any of these laws, all of these laws, deal with housing discrimination and cover that. Because I want to get you out in about an hour and a half and not take the entire day, I'm really just going to focus on the Fair Housing Act itself. But it's very broad in its coverage, and so I think when you're thinking about discrimination issues, if you are on the good side of the Fair Housing Act, I think it's safe to say that you're going to be okay generally. So what is the Fair Housing Act? Well, it was about a week after Dr. Martin Luther King was assassinated in 1968 Congress finally enacted the Federal Fair Housing Act. It covers the entire country. It covers here in North Carolina, mountain counties, Piedmont, coastal counties, the entire state. It is a very broad remedial act that prohibits discrimination in residential housing, right? There's that nice little picture there of LBJ with Mondale and Thurgood Marshall looking over his shoulder. That was the signing of the act itself. So what type of property does the Fair Housing Act cover? Well, it covers almost every type of property housing that you can think of. The Fair Housing Act uses the term dwellings, but it's really just residential housing. But it covers whether it's public housing, whether it is private housing, individual homes, multifamily housing, migrant housing, shelters, you name it, it's covered by the Fair Housing Act.
Jack, could I interrupt you real quick?
Yes, of course.
Could you try going to presentation view? I think it might be a little easier for folks to see the slides.
Sure. Let me. How's that? Is that a little better?
Yes, thank you.
No problem. So we talked about where it covers, but let's talk about who has to comply with the Fair Housing Act. So almost every person and entity in the residential sale or rental process is covered by the Fair Housing Act. For example, certainly landlords, property management companies, even the maintenance person, the receptionist, all employees and agents. But in addition to that, condo boards, for example, or homeowners associations, all of those are also covered, as are banks, lenders, insurance companies, appraisers. All of those entities and persons involved in residential sales or rental are covered and prohibited from discriminating by the Fair Housing Act itself. Now, I think you can see my picture and you can see that I'm wearing a blue shirt. And if you decided that you didn't want to rent to me because I'm wearing a blue shirt, well, I wouldn't be happy about that, but there's nothing illegal about not wanting to rent to people with blue shirts. We are not a protected category. Neither are attorneys, by the way. And so if you wanted to keep out me as an attorney, I guess, that also wouldn't be illegal. But there are certain protected groups that the Fair Housing Act recognizes, right? These are groups that have experienced a history of housing discrimination, not because of anything individuals may have done or not done, but merely because of the group that they are part of. And so when Congress and our state General Assembly with the State Act, when they enacted the Fair Housing Act, they did it, the impetus for that was the really terrible history of housing discrimination against persons of color, women, persons with disabilities, persons of minority faiths, people with families with children, people who are disabled, and actually for our State Fair Housing Act, an additional 8th protected category of affordable housing. Just to note that that affordable housing protected category comes into play if a local government were to try and keep out affordable housing specifically because it's affordable housing. That would be illegal and a violation of our state act. But I'm going to focus on really 1 through 7. And also then do a kind of more of a deep dive on disability specifically. I want to point out that number 5, sex or gender, now covers also members of the LGBTQ community, right? You don't see the terms lesbian or gay or bisexual or transgender expressly included among those categories there, but as a result of court interpretations of the language that's in the Fair Housing Act, I'd say it's a certainty now that housing discrimination against members of the LGBTQ community because of their membership would also be prohibited. Finally, I just want to note, you'll notice that these are very general terms. It says race. It doesn't say white or black. It says religion. It doesn't say Christian, Jewish, Buddhist, or Muslim. It says sex or gender. It doesn't say male or female. These are meant to be very broad. And so any of you watching, regardless of your race, your religion, your gender, your familial status, if anybody discriminates against you because of your race or gender, or any of these protected categories, that's illegal, right? Makes no difference what your race is. If you're being discriminated against because of your race, that is illegal, okay? Just for example. The type of conduct that's prohibited is, again, specific to residential sales or rental. So refusing to sell or rent or negotiate for housing, discriminating in the terms or conditions. So giving, for example, more services or charging more money or giving less services, charging a higher security deposit, requiring medical documentation from a tenant, things where you're requiring more or giving less to one tenant or another because of their membership in a group, in one of those protected groups, that would be illegal and discriminatory. But in addition, misrepresenting availability is also illegal just by itself. Now in today's day and age, people don't generally say, I don't want to rent you because you are X. People will smile and say, sorry, we don't have anything available. And the person will walk away not even realizing that they may have been discriminated against. So the mere misrepresenting availability because of somebody's race or gender or other protected status is illegal, right? But then statements also by themselves, discriminatory statements are prohibited. Certainly coercion, intimidation, kind of a no-brainer there. Harassment, again, easy to understand. Then that final term, otherwise make unavailable or deny housing, is meant to be so broad as to really include any other type of transaction that might occur even after the sale or rental has occurred, right? So this is, like I said, the Fair Housing Act is a very broad remedial law that's meant to cover as many situations and as many people as possible.
Jack, we have a couple questions.
Yeah.
One is it legal when landlords advertise rentals with no HUD allowed or no Section 8 vouchers allowed?
Good question. So whether one believes as a policy matter that housing providers should be required to accept Section 8 or some other HUD subsidy, it is not illegal here in North Carolina for a landlord to refuse to accept a Section 8 voucher. Now, having said that, it can't be a pretext, meaning a housing provider couldn't accept some HUD subsidies and decide not to accept Section 8 vouchers, for example, when the majority of individuals who have the Section 8 voucher in that area are, for example, persons of a protected category. So it can't be a pretext for discrimination, but there is nothing illegal or prohibited here in North Carolina in refusing to accept a Section 8 voucher by itself. Many states, yeah, I'm sorry, go on.
Sorry, I was going to jump in. And can you speak to the legality of local North Carolina cities or counties enacting source of income protection to their fair housing ordinances? Sure.
So recently, various fair housing agencies, human relations commissions around the state have expanded their coverage beyond what the state or federal Fair Housing Act requires. So specifically to expressly include veterans, for example, Orange County includes protects veterans, or the elderly has been included. Other local agencies, human relations commissions have included expressly lesbians, gays, bisexuals, transgender. There is a problem in North Carolina in that we are called a Dillon's Law state, in the sense that all power resides in the General Assembly as opposed to local entities, and local entities have those powers that are allowed them by our state General Assembly. And therefore, for some modifications or amendments that might affect economic relations, such as adding source of income protections, could potentially run afoul of that Dillon's Law concept. Now, there's nothing to prevent any city or county from making adding as a protected category source of income protection. The question would be whether they could enforce that. And I would imagine that a housing provider might push back and, in fact, maybe file a lawsuit asserting that the local entity did not have authority to add that source of income protection. But there's been obviously no court decisions on that. And if that were to happen, I'd be interested to see how it played out. It's my understanding at this point, I'm not aware of any local human relations commission or city that has added source of income. I'd be interested if that has occurred. So I'm gonna go forward. So let's focus. I went through those protected categories before, but I think that in terms of confusion that both tenants and housing providers have, and cities for that matter, enforcement agencies have, I think a lot regarding disability protection, there's just been a lot of confusion. And so I'm going to focus on that a little bit. When we talk about disability, it's again a very broad definition. So the Fair Housing Act's disability-based protections focus on physical or mental impairment that substantially limits one or more major life activities. So, for example, seeing, walking, understanding, talking, being able to interact with others. Those could all be major life activities, right? So a physical or mental impairment that substantially limits one of those major life activities would be a disability. Or merely having a history of such an impairment, even if you no longer have that impairment, if you're being discriminated against because of your having historically had that impairment, that's also illegal. Or being perceived as having such an impairment, even if mistaken. If I discriminate against you because I mistakenly believe you're disabled, even though you're not, that is still prohibited by the Fair Housing Act. And finally, associating with or residing with a person with a disability is illegal. Even if you yourself are not disabled, if there is someone in your household who has a disability and you are being discriminated against in some way by a housing provider because of your association or residing with that person with a disability, that's also illegal, right? So again, very broad in its coverage. These are just examples of protected disabilities, things, kind of that you would assume: blindness, deafness, a mobility impairment, a mental illness, a cognitive disability, somebody who has AIDS or is HIV positive, somebody who is either a current or former alcoholic, and somebody who is a former substance abuser. Current substance abuse is not protected as a disability. but former substance abuse is, right? So people have asked me, is COVID-19, is the infection from COVID-19, is that a protected disability? It's important to know that when you're determining a disability, whether somebody has one or not, that's an individualized assessment, meaning that it's really a case-by-case analysis. One size does not fit all, and you really have to look at the individual facts of that person to determine whether what they are experiencing is a protected disability or not. But we look to whether that impairment is temporary or long-term impairment, right? And so we know for COVID that some individuals might just feel terrible for a day or two. Others may have what's called long COVID and experience symptoms and impairments for many, many months, right? Or even ongoing, hasn't ended. Then we also look at the severity of the impairment. Is it a substantial limitation of a major life activity, or is it just something that's like the flu? And then whether somebody's perceived as disabled or having a history of that disability, all of those things could affect the analysis of whether COVID-19 is a protected disability. And then even in addition to that, there are certain high-risk conditions, comorbidities like obesity or pulmonary breathing problems that result from COVID-19, and they themselves might be a disability, right? So it is possible. I'd say it's not a definite. There's been no, that I'm aware of, no court determination that says COVID-19 is always a protected disability, but I just want to raise that it's possible, depending upon the individual facts of a person, their COVID-19 infection may be considered a protected disability. Certainly, like I said, long COVID, individuals who have COVID, the effects, the symptoms of COVID over a very long period of time, our U.S. Department of Justice and Department of Health and Human Services have determined under the Americans with Disabilities Act and Section 504 of the Rehabilitation Act, two other anti-discrimination laws, they have determined that somebody with long COVID can be considered as disabled, right? If that person's symptoms, if there is a physical or mental impairment that substantially limits one or more major life activities. So same sort of analysis applies like I just went through. There'd be an individualized assessment, to determine whether somebody's long COVID had that substantial impairment. And so I would argue that under the Fair Housing Act, the same sort of analysis would apply. And so somebody with long COVID could also potentially be considered disabled under this analysis, even though Department of Health and Human Services, HUD, Department of Justice, nobody that I'm aware of yet has done this analysis for, under the Fair Housing Act. But it's just important to understand that it is possible.
Jack, I have two questions.
Yes.
One is related to the protected disabilities of alcoholism and drug abuse. How
Yes.
does that relate to the criminal background check if possession charges are a result of the disability?
So I'm gonna get into the whole subject of criminal background checks and its interaction with disability later in this presentation, but certainly it is possible. I'll just kind of as a teaser, that somebody's disability can potentially entitle them to having that criminal background check analysis change in some way as it applies to them, right? Crimes that are directly related to somebody's disability may potentially be waived. It really will depend upon so many different factors, the type of crime we're talking about, when it happened, all of these things, the type of disability asserted. I will get into that probably about 10 slides from now, but there is, as you're saying, there is definitely the potential for an interaction between somebody's disability and a criminal background check, and whether that they can be excluded or not. So they are related. I will get into that in more detail as we go forward.
And the other question really quickly is, can landlords charge first, last, and security deposit? All three of those.
Are landlords allowed to charge a first month's and a last month's security deposit?
Can they charge both first month, last month, and a security deposit? So can they charge all three of those?
So in terms of fair housing and housing discrimination, as long as somebody applies that policy neutrally across the board to everybody, there is nothing illegal under the Fair Housing Act for somebody to, for example, say, I require that individuals be able to have income levels of 3 times the rent. Worth 3 months rent. So those sorts of economic requirements, as long as they are not a pretext for discrimination and are not being discriminatorily applied to some groups but not others. So as long as they are being applied across the board in a neutral way, there's no, based upon that alone, there's nothing that violates the Fair Housing Act by requiring that. Okay, so certainly it's illegal to intentionally discriminate against somebody because they're disabled, right? Whether it's a rental or a sales situation, whether it's somebody residing with them, right? But in addition, it's generally prohibited to inquire into the nature or extent of somebody's disability. For housing providers, they want to know, is this person going to be a good tenant? Have they been evicted before? Can they pay the rent? Is there a criminal history, right? Or what's their credit history? Whether or not they are a person with a disability really is nobody's business. That should not be part of the questions asked during any sort of tenant application, right? Certainly if it was situation where eligibility requirements would involve disability. So HOPWA housing for people with AIDS, you have to have AIDS or be HIV positive as an eligibility requirement in order to get into that housing. So asking about that certainly would be understandable. But generally speaking, housing providers should not be inquiring into the nature or existence of somebody's disability. Okay, the tenant, him or herself, may make that an issue, and then like by asking for what's called a reasonable accommodation, and I'll get into that in a moment. If they make it an issue, then it's possible. Then it's on the table, so to speak. But generally, if the tenant isn't raising it, a housing provider shouldn't inquire. But in addition to not intentionally discriminating against persons with disabilities, the Fair Housing Act goes further than that. Sometimes housing providers will be required to take affirmative steps to allow persons with disabilities an equal opportunity to live on the property. And those affirmative steps are called reasonable accommodations or reasonable modifications. A reasonable accommodation is really a change in the rules, policies, or procedures that is necessary because of that person's disability, to accommodate that person, to allow them the equal use and enjoyment of the property, right? So in this situation, although I generally say it's important to treat everybody equally, right? Kind of a fair housing mantra is treat everybody equally. In this particular situation, housing providers are actually may be required to provide a preference, to provide something extra to a person with a disability that they don't provide to non-disabled tenants. And that can be this request for reasonable accommodation. It can be requested at any time. It can be requested by a tenant applicant, by the person who's already an existing tenant. It can even be requested if there's a summary ejectment hearing at that late, at the eviction end of the whole continuum. So it can be also requested by anybody. It doesn't have to be the tenant, him or herself. It could be a social worker, an attorney, a friend, a relative. So this whole reasonable accommodation process, it's important as a best practice and to reduce liability for housing providers. It's important that you have written policies in place on how your staff will address requests for reasonable accommodations. You don't want to be responding to requests for reasonable accommodations differently in a kind of ad hoc way, right? You want to have a written policy in place. You want your staff trained on that policy. You want your retained attorney reviewing that policy to make sure that it is compliant with the Fair Housing Act. And so this is one of those important areas where you need to have written policies in place, right? You shouldn't be winging it. So does a request for reasonable accommodation, does it always have to be granted? No, it can be denied. Certainly if a person is not a person with a disability, they have no right to a request to a reasonable accommodation, right? A person has to be disabled in order to be eligible for a reasonable accommodation. But in addition, it's a request for a reasonable accommodation. If it's unreasonable, then you can deny it. So the question is, when is a request reasonable or not? Well, it's not reasonable. It's not a request for a reasonable accommodation if it would create a fundamental alteration in the services. If the housing provider is not already providing some service, right? And the tenant with a disability requests that new service be provided, it's not illegal to reject that if in fact the service is not already being provided. Like if you provide shuttle service to the mall next door to all of your tenants, and I'm a tenant with a disability, I can ask that you include me in that service. But if you don't provide shuttle service to the mall next door for your tenants, and I say, hey, I'm disabled, it'd really be great if you provided that service, that's a fundamental alteration in the nature of the services or programs you as a housing provider give to the other tenants, and you don't have to do that, all right? It wouldn't be seen as reasonable. Or a request for reasonable accommodation is not reasonable if it were to create what's called an undue financial or administrative burden. Now, any request for a reasonable accommodation is going to create some hassle, some additional paperwork that might have to be filed, some additional cost. That doesn't make it unreasonable. The question is it an undue burden, right? Is it an excessive cost or an excessive administrative hassle? Generally speaking, the more expensive some accommodation is, the likelier it would be seen as an undue financial burden. So while it's illegal to deny a request for a reasonable accommodation, if the request is not for a reasonable accommodation, then it can be denied. It gets kind of confusing. And that's why it's important for you to have a policy in place and to speak with in-house or retained counsel if you are a housing provider and a tenant is asking you for a reasonable accommodation, right? It's important to consult an attorney just to make sure that what you're doing, what your response is done in a fair housing compliant way.
We have a couple questions.
Sure.
Someone asked, What about adding an alert system for hearing impaired tenants, or who is responsible for installing or paying for the equipment or changing the stove, something like that?
Mhm. So individuals have smoke alarms, mandatory smoke alarms in their units, but those smoke alarms are usually auditory, right? They make a loud noise. If somebody is deaf, they might, as a reasonable accommodation, need to have a different alarm put in that is a visual strobe flashing light alarm, if that's, I think, what you're asking for. And so if that person is a person with a disability, I'd say it would be a request, a reasonable request. It certainly would be related to their disability for them to ask for a different type of alarm if their disability prevented them from using the alarm that's in place. And in that situation, if it was a reasonable accommodation request, then it would be seen as something that the landlord or housing provider would have to pay for. If it was a physical change in the unit itself or the property, what's known as a reasonable modification, and if it's a private landlord, the private landlord has to allow it, but the tenant would have to pay for it. If it's publicly funded housing, certainly a public housing authority or other HUD subsidized housing in some way, then the housing provider would have to pay for that modification. But I would think if you're talking about the replacement of a smoke alarm, I would see that as an accommodation and something that the landlord would have to pay for. I don't think that's a big cost, by the way. Replacing a smoke alarm with an auditory alarm with one that's a strobe light, I don't think that would be seen as unreasonable as an accommodation request. Is there another question?
There is. There's one. I think there's a few on this reasonable accommodation.
Sure.
I'm going to jump back up. There's an earlier one about reverse discrimination claims. So can you address ways to defend against a reverse discrimination claim? For example, a man is denied housing in a women's shelter or a non-veteran in veterans housing.
Well, let me just first start out that except for Orange County, I am not aware of anywhere in North Carolina where being a veteran is a protected status. Maybe in Cumberland County, they may have amended their local fair housing ordinance to include veterans, but otherwise veterans are not a protected category. Whether they should or should not be is a policy argument, in a policy discussion. But other than Orange County or Cumberland, they're not a protected status. So you can have certainly housing that is targeted to individuals. For example, if you had a women's shelter that where it's congregate dorm-like housing, I think that there would not be certainly a successful fair housing argument by an individual, a man to be in that congregate dorm housing. However, if there was, for example, a male victim of domestic violence, and that certainly happens, and it is a domestic violence shelter, and it had individual units and individual bathrooms, it's possible that an individual could assert that. I have not personally, I've been doing fair housing work in North Carolina for 11 plus years. I have rarely, I think maybe once, had somebody come to me and say that they were a victim of quote unquote reverse discrimination in that regard. So again, it's important I wouldn't call it reverse discrimination. Remember, I said, regardless of your race or gender or religion, if you're being discriminated against because of that, then that could state a fair housing claim and be illegal. But each individual's facts are different, and we would need to determine based upon that whether there was a valid claim or not. There is gender-specific housing shelters that occur, and to overcome that, like I said, I think factors of whether it's dorm or individual units, general large common area bathrooms versus individual bathrooms, there would be a lot of factors that I would have to look at.
Thank you. And jumping back really quickly to reasonable accommodation, can you clarify or confirm that if there are modifications to be made due to someone's disability, they're in a protected class, hearing impaired is an example they're using, that the landlord or the housing entity itself would be responsible for paying for changing out the smoke alarm and the door alarm or knocking doorbell to a light focus or a strobe
Okay,
light.
sure. So I do think that replacement of the alarm would be an accommodation and not considered a modification. Let's talk about something that clearly is a modification. Expanding a door frame to accommodate a wheelchair, for example, or putting in a ramp on the, to the unit. Those are clearly physical modifications, right? So again, if somebody makes a request for a reasonable modification, the housing provider has to allow it. But if it's a private housing provider, the tenant has to pay for it. Or a nonprofit agency or a church or a synagogue or a mosque, somebody other than the housing provider. If the housing provider receives HUD funds, is seen as a therefore as a public housing provider, even if it's not a public housing authority, if they're receiving HUD monies, right, then the housing provider would have to pay for the modification. And so that's the difference. For reasonable accommodation, housing provider always has to assume that cost, but it can't be an undue or excessive cost. In a modification, it depends who pays for it is really the big issue. Has to be allowed if it's reasonable, but who pays for it becomes the issue. And so merely receiving Section 8 vouchers doesn't make you a private housing provider. Merely being a tax credit property without any other HUD monies coming in to the property does not make you public housing. And so the question would be, is that housing provider considered public or not? And that would determine who pays for it. So I have a question for everybody. Everybody's been asking me a question. I have a question for you all. Can a housing provider violate the Fair Housing Act if they deny a tenant's request for a reasonable accommodation, even if the landlord harbors no intent to discriminate against that person with a disability? What do people think? Well, because we're short for time, I'll just give you the answer. Landlords can end up violating the Fair Housing Act by denying a request for a reasonable accommodation, even if they have no intent to discriminate, right? So there's intentional discrimination. People can understand that. But the mere denial of a request for a reasonable accommodation by itself, regardless of what's in your heart or your mind, may violate the Fair Housing Act and also be prohibited. And that's why it's important to understand this concept well, have a policy in place, have your staff trained on this policy, and to make sure that you speak with an attorney to look over and review your policy. Okay, so even if you are a person of goodwill as a housing provider, you may violate the Fair Housing Act by denying a request for a reasonable accommodation. I'm not going to look into what your intent was. I just want to know, did you deny it or didn't you deny it? And was it a reasonable accommodation or not? Okay. So there are a lot of different types of accommodations. I'm just going to talk about a few of them for lack of time. You might have a situation where you require rent being due on the 1st of the month, and if it's not paid by the 5th, it's considered late, and you might assess a late fee. But if I'm a person with a disability and I get SSI, for example, a federal public benefit related to my disability, and I get it on the 7th of every month, I'm always going to be late, and you're going to assess me a late fee. As an accommodation of my disability, I will ask that you do something for me that you don't do for any of the other non-disabled tenants. You allow me to pay the rent on the 7th or 8th or 9th, whenever I get that income direct deposited into my account. Everybody else has to pay by the 5th or they're late, and you assess a late fee. But me, the person with the disability that gets disability-related income, I am going to be allowed as a reasonable accommodation. I have to ask for it, right? To pay later. Now, the accommodation is not that I get to live there rent-free. I still have to pay the rent, but I would be allowed to pay later as a result of my disability-related income and how I get that income, okay? Here's another question. Tenants whose disability causes them to disturb other tenants by shouting and making loud noises in their unit can always be evicted by their landlord for breach of the lease. What do you think about that? Well, again, I'll give you the answer because time is of the essence here. So certainly disturbing other tenants, if it's continuous or extreme, could rise to a breach of the lease, or it may always be a breach of the lease. Whether it would be considered a substantial breach allowing for eviction, you know, I would say that it would have to be ongoing or continuous or of such an extreme nature. But if a tenant's disability causes them to make those disturbances, right, then as an accommodation of their disability, they might ask, don't evict me, allow me to control my behavior in some way going forward, but as an accommodation of my disability, right, as a reasonable accommodation, don't evict me for this instance. That doesn't mean that the tenant can continue to disturb his or her neighbors. They have to be able to come up with some plan going forward, whether it's taking medication, going into therapy, having some sort of intervention by the social workers, something that will prevent their continued shouting and disturbances. But they would, as an accommodation, they wouldn't be evicted for that instance, right? That would be the accommodation. Whereas for somebody who's not disabled and whose disturbances were not disability related, would not have that protection. So assistance and service animals. This is one of the most common reasonable accommodation requests, and also one of the most common source of conflict between housing providers and tenants. So it's important to know pet rules are fine. Pet rules are legal. You can have a breed restriction policy, a weight restriction policy. You can have a no pets policy. All of that is fine and legal and allowed, right? However, assistance animals and service animals are not pets. The law considers them like a device, like a wheelchair or a seeing eye cane. And so although you can have a no pets policy or a breed restriction policy or a weight restriction policy for pets, you can't apply those to service and assistance animals. Now, a service animal is an animal that is trained, right? A seeing eye dog is the most obvious example of a service animal, right? But an assistance animal requires no training. An assistance animal, also known as an emotional support animal or a therapy animal, they're just warm and fuzzy, and taking care of them can sometimes alleviate somebody's extreme anxiety or their depression, and can be a way for them to address a mental health disability. No training is required, whereas a service animal is generally going to have to be a dog or a miniature horse. Yes, a miniature horse. Congress did include that. I think you can see in the lower right-hand corner, there's a woman with a miniature horse walking on the beach. But for assistance animals, it can be any type of domesticated household animal. A lizard, a cat, a dog, a parakeet, right? Unique animals like a peacock or a potbelly pig, those require a higher standard to meet by the tenant. But ultimately, no training is required. And as a reasonable accommodation, somebody can have a service or assistance animal in their unit, even if you have a no pets policy. Any questions on that?
There are a few, as you might imagine. So one is, if you can clarify that landlords cannot enforce breed restrictions on emotional support for assistance animals if their insurance lists these as restricted breeds.
If their insurance, what was the end of the sentence?
If the housing, I'm assuming the housing insurance lists certain breeds as restricted.
Yes, good. Okay, great question. I've gotten that many times. People have asked about that. That's a really legitimate question. You need insurance if you're a housing provider, and if your insurance company excludes certain breeds of animals from insurance coverage, what do? Right? You're kind of in between a rock and the hard place, between the tenant with the disability who's seeking to have a assistance animal that may be one of those supposedly, prohibited breeds on the one hand, and the insurance company is coming at you from the other end. So as an advocate for tenants with disabilities, I would say my beef is not with you, the housing provider. My beef is going to be with the insurance company. And if the housing provider is willing to agree that if allowed by the insurance company to have such a breed in the unit, they're fine with it, then, I don't know that there's any conflict with the housing provider. It may be the insurance company that is violating the Fair Housing Act by restricting certain breeds and not providing insurance coverage to a quote unquote prohibited breed that is a assistance animal. So yes, it is a legitimate question and a legitimate situation. If that occurred, the advocate for the tenant would probably be in discussion with the insurance company and would be seeking some assurance from the housing provider that so long as it could be worked out with the insurance company, they would allow it as well. Right? So, yeah, so that would be my comment there.
If one other question, if there's a limit on the number of pets in a unit that's allowed, so only one limit, because these are not pets by definition, can there be multiple service or assistance animals in a unit? Yes.
So, one Fluffy the bunny, okay. Two Fluffy the bunnies, maybe. At what point, how many Fluffy the bunnies in the unit are allowed, right? So first off, an individual may have multiple disabilities. A person may have a physical disability, let's say the obvious, may be blind and need a seeing eye dog, and have depression and anxiety and need an assistance animal to deal with that other separate disability. So right there, you would have more than one assistance or service animal. But you could have a situation if somebody comes to you as a housing provider and says, I need an additional, I already have an assistance animal in my unit, and I need this second assistance animal, then you as a housing provider, rather than in a knee-jerk way saying no, you should go through the same analysis as you went through for the first assistance animal? Is the person a person with a disability? Is there a disability related need for that animal, right? In terms of a reasonable accommodation, it is possible. And I have seen situations where individuals were determined to need more than one assistance animal. Now, there are health and safety concerns that a housing provider certainly has, and those are completely legitimate, right? At some point, if there are too many animals in a unit, it can create a health or safety, a sanitation issue. And certainly, regardless of whether it's one animal or more, everybody has to be able to control and clean up after their animals, whether it's a pet or an assistance or service animal. And if a person with a disability can't control or arrange to clean up after their animal, then it may not be a reasonable accommodation. So again, case-by-case analysis, each individual situation needs to be looked at on its own facts, but it is possible for an individual to have more than one animal in their unit, but you as a housing provider would go through that reasonable accommodation analysis again for each animal that's requested, okay, to make that determination.
To have a clinical, do they need to document clinical need for support, assistance, or service animal?
So if somebody comes to a housing provider and says, I need a reasonable accommodation, whether it's an assistance, a service animal, or any other type of accommodation or modification for that matter, there's two things that a housing provider can inquire about. Is that person a person with a disability first? And is there a disability related need for that accommodation or modification? If the disability or disability related need is obvious or already known by the housing provider, they shouldn't be asking again or asking at all. If I'm in a wheelchair, it's obvious I have a physical disability. And it's obvious that I would have a disability related need for a wheelchair ramp, right? But I just told you a couple of slides back that you're not supposed to inquire into the nature or existence of a disability. What do? It's if somebody has a physical disability, it may be obvious. But if somebody has a mental health disability, it's not going to be obvious. And housing providers are not required to be mind readers. And you may not know already that somebody has a mental health disability. In that instance, when the disability, whether it's physical or mental, is not obvious or already known by the housing provider, then you can require verification of the disability and the disability related need for whatever that accommodation or modification is. What verification you require can be a source of friction. So a person being disabled, I've already told you, can be very broad, that definition, right? And so if let's say a mental health disability is not obvious to you and somebody comes to you and asks for reasonable accommodation, you can seek verification, but it can't be onerous or unreasonable. You can't say, I want to see your entire medical records, or I want to see the doctor's prognosis. What would suffice would be a letter from somebody that has firsthand personal knowledge of that person's disability. I always think as a best practice, having a healthcare provider provide that verification is best, but it's not required. As an advocate, I always, in the Fair Housing Project, we always go to healthcare providers to obtain such a verification letter. There's enough to fight about. We don't want to have to fight over that. And having that verification letter can verify that the individual is a person with a disability and has a disability-related need for whatever that is. But you have to be careful. You don't want to create unreasonable requirements in order to grant an accommodation. At that point, those could be considered a violation in and of themselves if you're denying a request for reasonable accommodation because the tenant refuses to provide you all of his or her medical records or give you sign a blanket release form. That would be considered an unreasonable condition. Okay, I'm gonna go forward. So already talked about this a little bit. So no magic words are required. I don't have to tell you I want a quote unquote reasonable accommodation or reasonable modification. My request can be oral or written, doesn't have to be on a specific form. It's certainly a best practice. It's always good to have it in writing, have it on a form, and if you're a housing provider, to have such forms for the reasonable accommodation request process. But you can't require that the tenant use your forms or use any form, right? So for those of you who are housing providers, you need to acknowledge receipt of the request. The law doesn't require it. This is just a best practice. I think this is a CYA. This is good for you as a housing provider, as well as good for the tenant, right? It's kind of a win-win situation. So if it's an oral request, you put it in writing, date it. If you want to sign it, have the tenant sign it. If they're willing, put a copy in the tenant's file, give a copy to the tenant. Make sure that you respond in a timely way. Don't, if you're a housing provider, don't think that, the tenant will forget. I'm not going to respond. At some point, an unreasonable delay becomes a de facto denial and can be a violation in and of itself, right? So as a best practice, respond promptly. Most requests, you can respond within a week's time. Now, there may be a reasonable modification request that is so complex, like a ramp or something else, you might have to consult an attorney or your maintenance person or somebody else, might take you additional time. But remember to respond in a reasonably timely way. So what can you ask for? I already went through this, right? Proof of disability and proof of that nexus or connection with the disability. Is there a disability related need for what's being asked for? Okay. Any questions on this? No? Okay, I'm going to steamroll ahead. Obviously unlawful to make discriminatory statements. And, that would just be your discriminatory advertising. You can't have in your advertising statements like active seniors or no children allowed, or, this is a Christian faith community. Things that would advertise a dispreference to members of any of the protected groups, you should not include in your advertising. Okay, advertising needs to be reviewed to make sure that it is compliant with the Fair Housing Act. So there are exceptions called the direct threat exception. If somebody were to pose a direct threat to the health or safety of a unit, and it's not based upon fear or speculation, then that's a possible exception to the disability-related protections, right? And I already mentioned current drug use is excluded. So there's a 1-year period of time in which a tenant would have to file a complaint, 2 years from if they wanted to file a lawsuit in court. Any questions before I move on? No? Okay. So criminal history. Last question for you all. Landlord has an absolute right to exclude applicants with a criminal history to ensure that they are providing other tenants and staff with a safe, crime-free environment. Well, at first glance, that statement seems okay. But when you look at it in more detail, you'll see that that's actually false. The answer to that is false. No housing provider has an absolute right to exclude applicants with any type of criminal history. HUD in 2016, and I'll get into this, issued guidance that talked about criminal history policies and when they could violate the Fair Housing Act. So bottom line, landlords do not have an absolute right to exclude everybody based upon any type of criminal history. It's much more nuanced than that. And again, this is one of those areas where you need, if you're a housing provider, as a best practice, you need to have a criminal history policy in writing, your staff trained on it, and have an attorney reviewing it to make sure that it's fair housing compliant. Okay, this is not something you want to do in an ad hoc way. There have been $1 million lawsuits and settlements, hundreds of thousands of dollars in damages and in costs to housing providers where they had absolute exclusion policies based upon criminal history, right? So it's not just the right thing to do to be fair housing compliant or the moral thing to do, right? Or the legal thing to do. As a matter of limiting and reducing risk of liability, landlords and housing providers need to make sure that they have fair housing compliant policies in place and their staff trained in them. It's very important. So HUD issued guidance on this. First, it's important to understand it is perfectly legal and allowable to have criminal history exclusion policies in place, right? Those policies are to presumably to ensure a safe environment for staff and other tenants. The problem in the past was that some of those policies were so absolute, such blanket policies that, yeah, maybe they kept out somebody that would pose a threat, a safety threat, but they also excluded a lot of good tenants, people who maybe had committed a crime in the past or may have been arrested in the past, but would make a perfectly fine tenant. And so they were overly broad. And so blanket policies are never going to be fair housing compliant, right? Policies that exclude based upon merely an arrest are not going to be fair housing compliant. Housing providers should not be excluding individuals merely based upon an arrest. The arrest is not proof of past misconduct. All it tells you is somebody suspected that person. It doesn't tell you anything else, okay? So first thing, don't exclude people merely upon an arrest. But convictions, that's another matter. Blanket prohibitions based upon any conviction ever, not good, don't do it, right? But tailored policies based upon convictions can be fair housing compliant and perfectly fine. So first, there has to be a conviction or a guilty plea. There has to be some sort of judicial determination of guilt that this person either admitted to or was found to have committed that criminal act first. Second, the policy has to be carefully tailored based upon the severity of the crime. Was it a misdemeanor or a felony? The nature of the crime, was it a violent or nonviolent crime? And how much time has passed since that conduct occurred? I represented an individual who was convicted of felony assault. So we're talking certainly violent and a felony, but he applied in 2021 and was rejected because of a 1984 felony conviction. And since 84, not only had he never been convicted of anything else, he had never been arrested for anything else. He was a perfectly good tenant, had a good tenant history, and was excluded because of that 1984 felony conviction. Was it wrong to do that 1984 crime? Sure. But should he be held excluded from housing in 2021 because of that, with no subsequent criminal history? No. It's not good policy, but it's also a potential fair housing violation. And so it's important, if you have a criminal history, policy, and it's perfectly fine to have one, to make sure that it is a carefully tailored policy that acknowledges and takes into consideration the nature and severity of the criminal conduct and when it occurred. Okay, important. Any questions so far?
I do have a few.
Okay.
Let me scroll back up here. It says, as far as criminal charges, we have a large property management group asking for letters proving folks have sought out rehab treatment when we're asking for reasonable accommodation on criminal charges that are possession.
Okay. So if I'm understanding, an advocate that's trying to get somebody into housing is being faced with a situation where somebody is requiring, regardless of the nature or severity of the offense and regardless of when it occurred, that there be some letter showing that the individual went through some sort of rehab program? Is that?
That's how it reads. I don't know if.
Okay, well, let me just say that there's no legal requirement. You can't require as a condition of tenancy that somebody provide you with a letter showing that they've gone through some sort of rehab program. Now, if you were trying to determine whether, if for somebody's substance abuse, whether or not they are a former substance abuser so that you can't discriminate against them on that basis, or a current substance abuser, which would allow you to exclude them or find them in breach of a lease, whether or not they went through rehab would be a factor that you could look at, certainly, and how recent the any sort of conviction was, or how recent any sort of substance abuse was, right? Would be factors. And going through rehab could be a factor there. But in terms of a criminal history policy, you could not require that. Now, in terms of an individualized assessment, I might, if I was a person with a criminal history, I might want to provide you with such a letter. And that would be something that you could look at in your individualized assessment of this person, right? And so it's allowed and could even be seen as relevant. I just don't think that you could require it as a condition of coming in. But I would want to get to you, if I committed a crime and was convicted, let's say 10 years ago, it would be to my advantage if I had a parole officer or some sheriff department or some government agency that I've done work with to vouch for me, that I've been a good citizen, or if I went through some sort of rehab program, if it was, substance abuse related, all of those things would be mitigating factors that I would want to provide to you if I had them. And that I would say certainly would be relevant for you to look at in determining whether this person would be a good tenant or not, despite having had a criminal history, right? So merely having had a criminal history doesn't end the analysis by itself. You want to do an individualized assessment. And those things I mentioned, the nature and severity of the offense, when it occurred, what their tenant history has been, right? They may have been convicted of something 5-10 years ago, but they have a great tenant history, and their last landlord thinks they walked on water. That's relevant to your assessment of whether to exclude them or not based upon their criminal history. Erica, I can't hear you. Okay. Let's see. I can't tell if it's you or me.
Anyone else hear me?
I can hear you now. Okay.
I'll take the question.
Okay. So I'm looking for who determines if the problem? Oh, okay, we did that. I'm just looking to see for this, for the question. I would ask that person, if that person who has the question maybe could unmute themselves and ask the question.
I have a question.
Yes.
So I have a client whose house has, or whose home is temporarily uninhabitable because of a squirrel issue. So my question is, while they're unable to stay at their home, is the landlord responsible for like paying for a hotel or anything like that while they're displaced?
Okay, good question. So this is a habitability issue. So there's a lease, whether it's written or verbal, between the tenant and the landlord. I'm going to pay you rent, and you're going to provide me with a habitable, fit place to live. And if that place is not habitable, and that squirrel infestation is so severe that it makes it, either it condemns it or it makes it impossible for me to live there, that would be seen almost like a constructive eviction by the landlord. And if I was an advocate